You'll hear me.
Yes, we can.
Yes, sir.
And you all can see my screen.
Yeah.
You can. There should be a presentation on the screen that says being admitted to the bar. Is that what
Yes,
you all
we're
are saying?
seeing that. Yes.
Okay, great. Well, thank you all for the invitation. Thank you for the opportunity to the Caroni Education District. My name is Leon Calitron, and I just want to go through this afternoon a few of my experiences, a few of my thoughts, because you all are very early in your career path. I would have started the degree program in 2008, which is quite a long period of time ago. So it's been now about 14 years that I've been through this process, and it's been a very, very interesting process, I have to say, and I've learned quite a lot. So I'll try to start off where Maya left off, which is she's still at the LLB stage. So the LEC stage is a period of 2 years, which you have the option to do that at the Hugh Gooding Law School if you're from Trinidad. There are actually two other law schools, one in the Bahamas and one in Jamaica, both of which same quality of education. And one of the interesting things about the LEC, it's a Caribbean agreement between many CARICOM states, and the decision that was taken is that all of the Caribbean islands, because of the fact that they had small groups of people that wanted to do law, they said, okay, well, we'll get together and we'll take everybody from a particular jurisdiction and we'll send them to one of the law schools. So when I studied, I actually studied in Barbados. And I met many friends there. I still have friends today from St. Vincent, from Jamaica, lifelong friends from Grenada. And it's always been a really interesting experience to learn how, even though we all learn the same thing, we all practice law a little bit differently. And law is it's a pervasive thing. It changes with time, it changes with people. And so I'll just say this about the LEC. It's a challenging course. I know a lot of people that dropped out at the LEC stage. I couldn't for the life of me understand why someone would go through the horrors of the LLB, but drop out of the LEC. But it's not a simple course. One of the things that I think you're pushed into when you get into the LEC is you make a decision between being perhaps a transactional lawyer or someone who is more involved in litigation. And I'll get to that in a little while in terms of the dichotomy between the two of them. After you finish your LEC, assuming we're dealing with Trinidad, you have to go to the law association to get what is called a certificate of fitness, and the certificate of fitness is what says that you're entitled to practice. I just wanted to say a little bit about that because at this stage, yes, you may study in Trinidad, but you may want to go to Guyana to work. You may want to go to Jamaica to work. These are possibilities, they're options. And one of the useful things about the LEC is that if you have the LEC, because of the agreement, if you possess the LEC in any one of those jurisdictions, which is a member to the LEC agreement, you can be admitted to practice. And the criteria for admission to practice is generally set out in the laws of the various territories. So that's a little bit on making a choice as to whether you want to do the LEC, or perhaps even you finish the LLB and then you want to go to the UK, or you want to go to Canada. There are different qualifications that would apply to that, but I'll come to that at the end. I don't want to dissuade you from the UK, but I think it's interesting to start at least from the perspective that let's try to figure out what Trinidad has to offer, what the Caribbean has to offer. So in terms of the career paths, you'd hear a lot of people say, okay, well, you can join a firm, or you can work for the state, or you can work for the judiciary, or you can become a private practitioner, or you can work in academia, or you can work for a company. And let's go into that a little bit more and what the differences between those things would be. So the firms are generally large commercial enterprises. Quite a lot of them have significant large clients such as the banks and so on, banks, insurance companies, and you would understand that when you get into the commercial world, the commercial world wants certainty, and certainty generally comes from a large enterprise that is resilient to injury, to risk, because mistakes occur on a regular basis, and sometimes it's simpler to have those issues be sorted out by a large enterprise, which has a large insurance policy, for example, as opposed to a small practitioner who is just this one-man shop. He may not be so resilient to injury. So that's an option. The positions at the firms are not extremely common. You would notice that at the end of the LEC, there are certain competitions that people enter, these types of things, and the firms pay attention to the people that enter these competitions to determine whether, is this the right fit for the firm. It's always an interesting question. Are you the right fit for a particular workplace? And you have to think about where you're going to fit in, because it's an important question. I want to talk a little bit about government, which has a lot to do with my postgraduate qualification. So I'll just tell you a little bit about my story. I finished the LEC in 2013, and then I worked at the law school for a little while, for just for about 6 months, and then I came into private practice with a private practitioner who specialized in something called judicial review. The judicial review is generally the claim that a private individual, a private actor, would make against the state if they are wronged by the state. So a simple example: someone has a police officer has locked you up incorrectly. We call that false imprisonment. Those types of claims, or a police officer has prosecuted a matter maliciously. Those are the types of matters that I've done a lot of work in, and that type of matter was very, very interesting to me, because it was a very David and Goliath sort of situation, where sometimes you think that you can't fight back against the state, and we've proven time and time again that sometimes the state is wrong, and it's always, every time I sit with documents. Sometimes I would like to show you the files on my table. Sometimes they're this big. I learned so much about the inner workings of the state, the inner workings of bureaucracy, and people make mistakes, people make errors, and someone has to be there to correct and to right those errors, and that's essentially what I think law is about. Primarily, there's a Latin maxim. I won't bore you with the Latin, but it just says essentially that for every wrong, there must be a remedy, and there should be no wrong that occurs that is without a remedy. So that is what the courts do. They are empowered by an act of parliament to create and to fashion remedies, and sometimes we come up with new remedies. How do we fix things that have gone wrong in society? How do we fix runaway business? How do we fix runaway government? And all of these things are questions that we deal with on a regular basis. So going back to the point about government, you have the Solicitor General's Department, which is the civil side of the government legal service. You have the Office of the Director of Public Prosecution. Someone asked a little while ago how you become a prosecutor. So you'd finish your LEC, obviously, and then you would make an application to the Judicial and Legal Service Commission for placement in the office of the DPP, which is a great idea, because we lack people in the DPP's office. The DPP's office is always talking about how understaffed they are, and it's a great space to learn quite a lot. It's a great place to help, and someone also asked about being a judge, but I'll just talk a little bit about a different path, which is that of a magistrate. Sometimes the magistrates generally come out of the office of the DPP because they would have learned the process, having been there for a period of years. And it's also an interesting path. There are also various ministries. So the Ministry of Education would have a legal office. Sometimes you have these small special purpose state enterprises. They also have legal officers. Then you have the state bodies such as TNTech and WASA. They all have legal personnel. And the point being that there are lawyers in every single walk of life. So you would find that no great amount of paper is produced without a lawyer being involved at some point in time. The simplest things, you produce a rent contract for tenancy, a tenancy agreement for renter. You need to have a lawyer look at it. Extremely simple things. As someone owes you a sum of money, you need to approach a lawyer to take that individual to court. You also have the opportunity of going into the private sector, and the private sector generally pays relatively well, and the opportunities in the private sector, but it's the type of thing that you really have to be, I would say, multi-skilled, because when you're getting into the private sector, you want to come there with a certain amount of business acumen, and that business acumen these days at least means a little bit more than having law behind your name, which is extremely useful. What is a lawyer's real ability in Trinidad? He is the one that has access to the court. What is said is that we are officers of the court, and we have rights of access, rights of audience in front of the court. So a layman cannot come into the court and speak to the judge unless the judge wants to speak to him. We have that opportunity to be able to file documents in the court, and to ask for a hearing and say, "Judge, please hear me." And that is essentially where you can exert your power, exert your thoughts and your ideas on the machinery of state. So I'll tell you again a little bit about what I do. I'm a private practitioner, so I've been in private practice for 8 years now, and I've been in what I referred to as chambers. So when you come out into chambers, essentially what occurs is that you have a relationship with a senior practitioner who you share office expenses and so on, and that individual, it's sort of a symbiotic relationship. They share work with you, things that they can't manage, and you do work for them. So the arrangement that I'm generally engaged in would be someone asks me to do research for them, and you can exemplify your talent with your research, and after a while it becomes in demand. So I'll just deviate a little bit from that, and so you might be thinking, should I do postgraduate qualification in law? Is that necessary? And I have postgraduate qualification in law. Sometimes I wonder why I did it, but it teaches you quite a lot in terms of having an overarching view of the subject that you're doing. It's always important and interesting to learn something in a structured manner, and so I think in that regard, yes, it could be useful. But the legal profession is one where once you reach a certain level of attainment, continuing professional development is not as yet required for continuous registration in our profession, but it soon may be required. So there's also, and I think Maya referred to it a little while ago. She referred to the concept of going to work for the judiciary, which is a relatively new concept. New in the sense that it started when I started, which is about 8 years ago. And you can be Judicial Research Council, which means that you work together with a judge, and you help them draft their judgments, and you help them do opinions on particular things. It's a very, very interesting and I would say academically engaging path. So I wanted to talk a little bit about the international paths, which is something that I have an understanding of, but it's not something that I've gone through, but it's something that I'm aware of. So one of the things that you can possibly consider is, even after you've done your LLB, there are various bodies, and so let's take Canada, for instance. There would be a body called the NCA, and what the NCA does is that it assesses your qualifications, and then you decide, instead of doing the LEC down here, you go up to Canada and you write certain exams, and that in itself becomes your pathway into the Canadian legal profession. There are similar paths in New York, the UK, and I know several colleagues who would have done that, and it's a sensible path, sensible option. One of the things that you do have to think about, however, especially in Canada and Commonwealth jurisdictions, you have the issue of finding what is called a pupillage. And so I referred to a little while ago, completing your qualifications, becoming a lawyer, but then finding a spot, finding somebody to work under. And that is a very important thing. And I think it's useful. And that's one of the reasons that I came to give my opinion or my thoughts on this, because we see every year that there are about 300 lawyers that come out. And we ask sometimes rhetorically, where are they going to go? So I don't want to pull wool over your eyes and say, well, look, this is a profession in which there's an indefinite amount of space. I do my best to try to bring people into my office and to assist and so on, but it's sometimes difficult. Resources are strained, that sort of thing. Now, I'm seeing that there's a request to rejoin the main session. If anyone is still with us from the CD team, could you tell me whether I have to rejoin or should I continue?
Sorry, can you repeat that, Mr. Kalicharan?
I'm just seeing that someone is asking for us to return to the main session. Is that, do we have to do that now?
Oh, no, you go right ahead. I'll let you know when it's time to wrap up, okay?
Right, understood. All right. So just going, I don't know if Delano is here. If he is, yes, I think he's here. So he was asking how to become a judge, and it's an interesting question, and I think you should think about it. It's a very, very demanding job. So when you qualify as a lawyer, you're 0 years in practice. So after 15 years, you have 15 years in practice. So judges generally in Trinidad have no less than 15 years of experience. And they can have experience in various places. They can have experience in the office of the DPP, which is one path to become a judge. You can have people who work in a firm, such as Justice Kokram, Justice Rahim. Both of those individuals were at firms, MG Daly. Justice Rampasad was at Rampasad and Company. Then you have judges who are drawn directly from the private bar, such as Justice Nelson. He was taken directly from the private bar and appointed to the Court of Appeal. Chief Justice Archie was actually the Solicitor General in the Cayman Islands before he was co-opted to become a judge of the Trinidad and Tobago High Court. So they're drawn from a lot of different places, and then there are other types of judges as well, apart from judges of the High Court. There are judges of the Industrial Court. There are judges of the Environmental Commission. There are judges. There are other subordinate tribunals and other judges and different requirements in terms of how those persons become part of the organization. So these are just some slides with some notable judges. This is Chief Justice Dela Bastide. This is Chief Justice Satnarayan Sharma, former Chief Justice. And just to give you all a quick understanding of what court is and what court is about, because that's what I do. I'm a litigator, so I will be able to give you a good understanding as to what a litigator does. I did not do a lot of transactional work in my career, but I've done enough to know that I don't like it very much. But I like court, I like litigation. And it's not because I think that I'm a good public speaker. It's not because I'm extremely extroverted, because I'm none of those things. But the things that I think make for a good litigator are good written skills. You need to be able to express yourself competently in writing. I see when I'm reviewing work from juniors, so very often poor grammar, poor structure, and it shows that they don't read. So if you want to become a lawyer, this should not frighten you. The thickness of this book should not frighten you. You should be excited by, being inside a book and living inside a book for days on end. That if you like that, then this profession is for you. If it's not, then you probably should consider something else. Just in terms of what the court system is, you have the High Court, and then from the High Court, when a judge makes a mistake, which they invariably do from time to time, you have the you have the Court of Appeal, which is composed of at this stage, about 12 or 13 different judges. Those justices of appeal, and they revise and they correct what the judges of the High Court do. They do that both
Mr.
in.
Kalicharan,
Yes.
in 2 minutes, we will close the breakout room, okay? So just wanted to notify you. Okay.
Okay, thank you very much. So this is what the Privy Council looks like. This is in Middlesex Guildhall in the UK. And I realize that there are quite a lot of women in this group. And I just wanted to make the point that even though quite a lot of the other pictures that I had in the presentation were of men, this shows that she was once the lady president of the Privy Council, and it shows that at the highest levels that women are capable and competent. Right now, even half of our bench, our High Court bench, is composed of women. So it's an important field, so that I think that it's something that you can devote yourself to. If you study hard, you will enjoy it. And yes, so this point about the transactional lawyer, litigation lawyer divide, you can read about it a little bit, but transactional lawyers essentially do a lot of documents. They prepare a lot of documents. These are the salaries that the expected salaries, and in terms of litigation, these are the hourly rates of some of the senior counsel, such as these folks that they make per hour. So it's a pretty large sum. So that's it. So thank you very much for listening. Thank you very much for your attention. I'm not sure how much time we have for questions.
We have 1 minute left. If anyone have questions, you can feel free to ask Mr. Kalicharan.
I hope I answered the question, Delano. Thank you. Yes, go ahead.
I was wondering, right? Is it possible from someone from the Caribbean to ascend to the Privy Council? And or between the two, should we choose the Privy Council or should we choose the CCJ due to the phasing out thing that I see it happening?
Right, so I know that you had a very, very interactive session there with our two lawyers. So now we move on to our next guest speaker, Judge Ramchand Lachmidiyal. The floor is yours. The virtual floor is yours.
Okay. Good afternoon to all.
Good afternoon.
My name is Ramchand Lachmidiyal. I'm an attorney at law by profession. I became an attorney in 1978. I started in 1973, having left Presidential College of Commerce in 1972. I was a member of the Industrial Court from 2000 to 2019. So I spent 19 years there. One little housekeeping or correction. I'm not a judge of the court. We are not referred to as judges. We are referred to as members. So I was a member of the court. I suppose one of the main reasons for that is that the members of the court are not all lawyers. They have some lawyers, but they also have other people. So to become a member of the court, you must be first trained in certain disciplines. One is law, one is economics. So if you're an economist, you can apply, and if you are successful, you become a member. The other one is accountancy. So accountants are members. And you have people who are trained in human resources, they also become members. And you also have people who are trained in industrial relations. So you may very well have someone who probably became a trade unionist, now out of school, got involved with a trade union, became a trade union, has a lot of experience in the trade union movement, and that person may apply and might be successful and be appointed a judge. That person is not by profession, but the person is appointed a member, sorry, not judge, member of the court. Person may not even have 5 levels, but because of the experience possessed, person will become appointed a member. Now the industrial court is a court that was established by law, is a creature of the statute, so its functions are limited by the statute that created it. And basically the industrial court deals with matters involving industrial relations, which will include disputes between employers and workers, or trade unions who represent workers and employers, or sometimes even workers and workers, or employers and employers. And some of the matters dealt with in industrial court would be trade disputes, which simply means a dispute involving terms and conditions of employment. So for example, if a worker is dismissed and he feels that he was unfairly dismissed, he can go to his trade union and they can raise a trade dispute. Now there's a procedure to be followed, and I wouldn't want to go into that, because it will take a longer time than time allotted to me. But you have to report it to the Ministry of Labor and so on, and it goes through a process there. And if it can be settled at that level, then it goes to the court for settlement. And that is where the court now plays the role of a court, because you have to hear the evidence and you have to make a decision. One of the features of the court, though, is that the court is not bound by the strict rules of evidence, as in the court that Mr. Calitron is speaking about. And there are very good reasons for that, because sometimes you may want to refer to something or talk about a document which is only in the hands of the employer. You may not be able to produce it, or refer to it, or read from it, because the employer has it and he's not giving it to you, because the dispute involves him. So that is something that is peculiar about the industrial court. And you may find that there might be a worker might serve a company and works overtime, and the employer refuses to pay overtime rates. All those could be trade disputes. You may apply for sick leave because you are sick, produce a medical, the employer refuses to pay. That too could be a trade dispute, and different things. Or you are due for an increase in salary, and the employer doesn't want to give you the increase. You can go to a trade union, raise a trade dispute. The industrial court also deals with matters under OSHA. OSHA stands for Occupational Safety and Health Act. As you know, there has been a lot of talk recently about OSHA. Some people refer to it as OSH, the OSH Act, Occupational Safety and Health Act. And this basically deals with safety in the workplace and following certain procedures and so on. So the industrial court is one of the courts that has jurisdiction in matters involving health and safety in the workplace. There are certain provisions in the OSHA which gives jurisdiction in the magistrates court, And then there are certain provisions where the jurisdiction is conferred on the High Court. But the majority of it is in the Industrial Court. The Industrial Court also deals with matters pertaining to maternity protection. As you know, we have the Maternity Protection Act in Trinidad, which is to protect women who become pregnant whilst working. And there are laws stating how the employer should treat with a worker who becomes pregnant and what benefits they're entitled to. And one of the main features of that act is if a woman becomes pregnant whilst on the job and she has to take maternity leave, and it's spelled out in the act how it is, when it commences and when it finishes and how much leave it is. When the person returns to work after giving birth to a baby, you cannot alter the terms and conditions of that employee. In other words, you can't demote them. You can't reduce their salary. You can't put them to do a lesser job. In other words, you have to put them back in the same position that they were at the time they took the maternity leave. The Industrial Court also deals with matters involving minimum wages. As you know, there's a Minimum Wages Act in Trinidad. I believe right now it's $16.50 an hour, or $15.50. So if you are working for someone and they are paying you less than that, you can bring a dispute in the Industrial Court, where the parties will be summoned, that is the employer will be summoned and you will be summoned to trash out the dispute. And there are certain rules and guidelines laid down in the Minimum Wages Act that you have to follow and so on to have that dispute resolved. We also deal with, the Industrial Court also deals with collective agreements. Now, a collective agreement is really an agreement between a trade union and a group of workers in an organization where they set terms and conditions of employment. So that if there is a dispute concerning the interpretation or application of a term in a collective agreement, the matter will come to the court and the court has to make a decision. Sometimes parties are negotiating for a collective agreement and they may settle some of the items, but some of the items, and especially things like salary increase. So sometimes you're reading newspaper or here, the employer is offering 000, right, or 100, and the union say no, we want 12, 10, 8 or something like that, 10%. So when those things happen and the parties can resolve the issue, the matter is sent to the court will hear the evidence, and the court will make a decision whether the workers are entitled to an increase and how much. Of course, you have to produce your statistics and so on to show things like the rise in the cost of living, the viability of the company, and the other hand, because every company is not making money, they can't pay an increase. But all these things are trashed over that level. Now, the Industrial Court is a court of first instance, meaning that the matter goes there, and if you are dissatisfied with the decision of the Industrial Court, you can apply to the appeal to the High Court, to the Court of Appeal, sorry. But an appeal only lies to the Court of Appeal on a point of law, or if there's some illegality. So that if the court gives a ruling that is wrong in law or makes a mistake, then you can appeal to the Court of Appeal and the Court of Appeal will give a decision. And because of our system where we still have the Privy Council as our final court of appeal, if you are dissatisfied with the you can go to the Privy Council. So industrial relations dispute, which has started in the industrial court, could end with the Privy Council, where decision will be rendered. And as you would realize, all the parties will be bound by that decision. So basically, that is it. It's a very interesting job. You meet a lot of things. In fact, even as an attorney, when you come out of law school, you may ask yourself, it happened to me, I ask myself, how do people get themselves in this situation or these situations? But you might be surprised to know how people get themselves in situations. And sometimes you wonder, what were they thinking when they get themselves in situations? But as I always tell clients, and this is something if you are open to become a lawyer, that what they are doing last, they should have done first, and that is to seek legal advice. So you don't go and sign documents, and enter contracts, make agreements, do things, and play your own lawyer, or you talk with some bush lawyer, as we say in Trinidad. And when you get yourself in a problem, you come to a lawyer now, and expect me as an attorney to work miracles. I tell my clients, I am not Jesus Christ, and I can't work miracles. But if you follow the procedure and you do what you are supposed to do from day one, a lot of these problems that people find themselves in, they would not find them in those situations. So the point is, the law is there, the law is to be applied, the law is to be observed, and if people go about their business in the right way and in the proper way, probably litigation might decrease in this country. But generally, we are a very litigious society. If you look at somebody hard, they want to sue you, or they want to do something to you. That is how we are. But people, and lately we have been introducing mediation, because the whole idea is to reduce the burden on the court system, and where the judicial officers feel that matters could be settled without the intervention of the courts, persons are referred to experts who can assist them in coming to an agreement. Because many times some of these disputes really don't need a judge or magistrate or lawyer to have it settled. It's just that people have to be reasonable and see each other's standpoint and come to an agreement. And everybody happy. Because remember, at the end of the day, even in industrial relations, at the end of the day, the parties have to live together. The workers still have to work for the employer to get a salary. The trade union still has to represent the workers in that organization. So you can fight how much you want, but we still have to talk to each other afterwards. We still have to meet and treat with each other. So that is about all I can say at this time. If there's anything, questions, I'll be happy to answer as best as I could. Are there any questions? Yeah.
Okay, so it seems as though you did an excellent job. The students are absorbing all what you are saying.
Well, all I can say is a very interesting field, and if people are interested, they can get involved in industrial relations because you get to meet people from all walks of life and you get to experience a lot of different situations. And 99% of those situations are real life situations because it really, those situations really deal with bread and butter issues. And it is only then you can really understand what people go through and how people have to balance everything, both employers and workers. Because remember, the employer wants to maximize profits, he invests his money, he expects a return. The worker has to live, he has to take care of his family, he puts out his labor, he expects to get his salary when the pay period is up, whether it's a day or a week or a month or whatever, a fortnight. And sometimes there are disputes, but they have to be resolved. I should point out that the Ministry of Labour plays a very important part in this whole procedure because trade disputes must be referred to the Ministry of Labour before you come to the court. The reason being that the Ministry of Labour must be afforded the opportunity to conciliate in the matter and try and resolve it without it being brought to the court. It's only if it cannot be resolved at that level, it reaches the court. Any questions from any students?
I guess we don't have any questions.
That's good.
So on behalf of Carnegie District, we say thank you for taking time and to impart your knowledge with our students.
Thank you for your opportunity.
Thank you. Okay, so we are moving on to our last guest speaker. I'm not sure if the ATS representative is here. The representative from ATS. Is ATS in the house? Okay, so I guess the representative isn't here. So now I'm going to hand you over to my colleague, Mr. Lovell, to leave you with the closing remarks.
So I'd like to pardon my cruise ship in the back, students. That's where I dream to be. But we really want to thank you all for your attendance and participation in our program this evening, or this afternoon, rather, for taking your time to be here. We hope that you were benefited from the presentations from our respective presenters. I'm sure that everyone here would have come away with something that they can use in one way or the other, if not to benefit themselves, maybe even share with a fellow schoolmate or classmate as well. Would also want to once more repeat that expression of thanks to Mr. Lakshmi Dial. Thanks very much, sir, for that quite informative presentation as well. It's well received and greatly appreciated. I'd like to say thanks again to you and to all our presenters that would have preceded as well, if any of them are still here. I'm not sure if they are. And of course, our technical team, as always, and my colleagues. Thanks to you as well. Students, without you, this would not have been possible. We do this for you, and we hope that you can join us again next week when we have an equally interesting and informative program as well. All right. I see someone is inquiring if it is that they will be able to access the recordings. What I would advise you is, if it is you can liaise with your respective guidance officers, we will try to make arrangements through them at your respective schools to see what we can make available to you. So continue to liaise with them, if that is okay, and we will see what arrangements can be made to get some of these recordings to you as well. All right. Any other thoughts and comments? I think that's about it, guys. So would like you to stay safe and remember that next week we have another installment of our virtual career fair in your interest. So tell a friend to tell a friend, and see you again next week. Be safe. Bye-bye. I guess that's it, guys.
That's a wrap.
Wow. Awesome. You guys, it did well.
Yeah, it was really good.
And you all,
Like
yeah.
a great production.
Yeah.
High five. High five.
Yeah. Definitely. Definitely. Well,
Banana applause.
We could go.
Yeah, that's it, right? So we'll talk on the chat. Bye.
Okay, bye guys. Enjoy your
Okay, guys.
afternoon.
You too. Bye.
Adios. Ella. Okay, bye. Go on. No response. Silence.